Good morning, everybody. So I did a quick read through and more of a reaction to the now unsealed Blake Lively loan out agreement. It was just a general like, well, let's have a look, see what's in there, what's the tea, and there was a lot of how much how much allowance is she getting for meals a week? $1,000, or she got 10% of the film's profits. Are we kidding? And then there was a lot of laughing at the suggestion that she might be nominated or even win an Academy Award. But I did want to, I've been asked a lot questions such as, did it have a governing law, a choice of law? And it does here in paragraph 15.1, California. So that is there. I was also asked, though, what would be the likely effect on her claims. And I actually looked into this way back in March, actually. At the time, we didn't have the full 30 plus pages of documents. We just knew that the agreement had been signed as Blakel Inc. I can't remember where that came about. But anyway, so yeah, I did a post on it back then on the basis that, in my opinion, she was technically a subcontractor, but I felt at the time she would still be protected under Title VII because there was no indication of how much control she had. We now have that missing context. And also, Blake Lively herself kept referring to herself as an employee, which kind of caused a bit of confusion. So I'm now revising my opinion on that based on what we now know. And the fact is that Blake Lively actually had a huge amount of control. Just to kind of show you, I mean, she could very much, there were so many things that would not be done without her consent, etc. I'm just looking here though, but there were some areas of this which were just absolutely wild. Sorry, I'm just trying to find it. There's obviously things like the names and likeness and all that. That's fairly typical. I'll start here because I'll have to go up and find it. But I mean, she expressly had control over whether she did nudity and simulated sex scenes. These conditions have been negotiated. So this one here, paragraph 17. I think this is one of the exhibits. Artists shall not appear nude or be required to film any scenes in the nude to appear in any simulated sex scenes without obtaining her prior written consent. The company also agrees not to use any body double to simulate artists' appearance in the nude or in any simulated sex scenes without obtaining artists' prior written consent. Furthermore, companies shall not digitize artists in any manner to simulate artists' appearance in nude or in any simulated sex scenes without obtaining artists' prior written consent. So that's that is quite probably a fairly standard thing. that higher ranking actors, actresses can ask for. There was something really, obviously, the executive producer credit, not just the credit, the location of that credit in the main titles, in paid ads, where her credits were in general, like that she was allowed to say exactly where they could be. They had to be of a particular size, above the movie title first. There was an awful lot. There's also accommodations. Right, yeah, here we go. Her accommodation, if she elects, so that's a choice, that's control. If she elects to stay overnight in Atlantic City, New Jersey, company shall provide artists with one suite at mutually approved hotel. So she had control over the hotel. Ground transportation. Last sentence, artists shall have the right to approve the driver and car. Dressing facilities. They will provide a use of a single pop-out star trailer for artists' use each day, which shall be mutually approved by artists and no less favourable in any material respect than provided to any other cast member. Ground transportation. These are in different locations, so it sounds like I'm repeating myself. I'm not. These are different locations. Again, ground transportation artists shall have the right to approve the driver and car. What is that? There's such a lot to navigate through. So she had right of approval for all photographs, stills, etc. On her likeness. She had right of approval over dubbing. Okay. And then we get to hear the artist's appearance. Bottom, artist shall have mutual approval over such alterations. So she's in the event, company requires artists materially alter her hair in a manner that is not so easily able to be restored. Prior to artist change of appearance for the role, artists shall have mutual approval over such alterations. There was one though, I was like, no. She really got control over that. Does she have to pre-approve that? She had approval over her biography that was to be used. Arguably as well, the company quite generously was prepared to provide round-trip air transportation of a private jet. And artist shall have right to approve the jet. She could literally approve the plane. Which is Wow. I mean, it's quite spectacular. She also had sufficient control over her contract to be able to say, I'm not going on that talk show to promote this film. I've got issues. I don't like the host. I don't like the show. So, she wasn't compelled to do all the talk shows that Wayfarer or Ends With Us movie told her that she had to do. There was also all the box office bonuses, the award bonuses. I'm not familiar with whether they are standard, whether all the other cast members, like young Lily, young Atlas, whether they would have had all that written into their contracts. But Blake Lively did. She was entitled to an amount equal to 10% of the defined gross proceeds of the film, which was, you're looking in the region of about 40 million, 35 to 40 million dollars on top of everything else. For me, though, it's this paragraph I find incredibly interesting. So this is the exercise of consultation and or approval rights. This is all of the stuff that Blake Lively has the authority to approve. And there's a lot. So her hairstylist has been pre-approved, and Carol. Her makeup artist, Vivian Baker, was pre-approved. A wig maker, Peter Owen, was pre-approved. A stand-in and stunt double, and we know from the 17-point list that was also who she approved. This expanded quite considerably to include producer, composer, and so many things. But this caught my eye. The director, Justin Baldoni, pre-approved. And co-lead for the picture, Justin Baldoni, pre-approved. She had a say even in his roles, which is I think that's nuts, but there we go. So the overall message here is this woman had a hell of a lot of control, comparable to the studios themselves. And this is not even at the point where she's trying to do her takeover. This is not where she is leveraging her threats. This is the agreement that they entered into upon her getting the role. And it doesn't matter that it wasn't signed. I had a lot of people say, but she didn't sign it. It doesn't matter. She performed the contract, i.e. she provided her acting services and performed the contract. She was remunerated by Wayfarer. So there's implied acceptance. So you don't need a signature. They performed the contract essentially. I found that absolutely amazing, that the amount of, when you go through this, the amount of control she actually has. Absolutely, she is an independent contractor. Absolutely no way is she an employee. And there is no power imbalance. I mean, this is a woman who's alleging that she wasn't even given breaks for breastfeeding. She was given so much for what was a mediocre job. And it's really I really hope that they bring this into the motion for summary judgment. So, as an independent subcontractor, Title VII does not apply to her. Those claims should fall away. FIHA does, but despite the choice of law being California, nothing in this, any referrals to transport, the location, where she's going to work, all point to New York. And I think that Wayfarer made a fantastic argument on the extraterritoriality on that. I'm hoping to see both Title VII and FIHA fall away, because this now paints a picture. And you can see now why it was never included with her complaint. Because if she had included it, then it might have made it would have raised questions. But her complaints say, very clearly, I'm an employee. And that was my thinking when I wrote my post in March, is, well, technically she has signed a loan out agreement. Her company, Blake Inc., is loaning her out, Blake Lively, out for acting services. I mean, there's still a path. Without context, there's still a path to be protected under Title VII with Assembly Bill 5, and that's what I was thinking originally. That was where my thought process went. However, I don't think that anymore in reality. But I was thinking Assembly Bill 5, that might bridge the gap. Now we know the level of control she actually had. There is not by any stretch of the imagination would she be considered an employee. And it arguably, she subsequently, the executive producer, I think people get confused over executive producer credit and the PGA producer credit. So the executive producer credit is just like it's just like a ceremonial title. It does nothing. She's not expected to perform anything for it. So the fact that it's in here, I can't find it. It is part of this contract is for the executive producer credit. Oh yeah, here 6.3. There's nothing else added to that. She's not asked you have to do this. It's just a credit. It's the PGA producer credit she went on to get. And a large part of the reason why she got that, and I have said this before, I've done an entire post on it. I will probably put a link in it. I've always said this 17-point list, it bothers me quite a lot. Oh yeah, this is where we got the loan out. Like we knew that she contracted under Blake Link. It was from this. But an intimacy coordinator, that was not built into her clause on the nudity and simulate and sex scenes. She didn't require an intimacy coordinator. There was no mention of one actually in there. She's obviously approved all these various people in roles. Todd Black being one as was he a producer? There's to be no spontaneous improvising of any scenes, etc., etc. You know, when you look at her actual loan-out agreement, that's already in there. This looks like she's added something new, this section 3. She hasn't. It is already in her loan-out agreement that the only thing it's added is the intimacy coordinator, which she never negotiated in the first place, and Wayfarer, off their own volition, hired one. But then we get on to all of this. Again, this is here as well. This looks like it's like, oh, we need all these new protections because I'm not protected. There should be no rehearsal or filming of artists, including artists' approved body double, of any nudity, partial nudity, or simulated sex, except as expressly permitted in accordance with the nudity rider. The nudity rider is a whole separate thing, but also this clause is also part of the the no nudity, no sex scenes. This is nothing new. The company needs prior written consent. That's what that adds. And when I'm looking at it now with fresh eyes and taking into account everything, my personal feeling is, why did she do it? Well, yes, there was the takeover of the film, sure. But I have said before, and I will stand by it, in my opinion, that 17-point list is really setting herself up for the PGA. Because if we look at both paragraph 2 with, no scenes of simulated sex, nudity, partial nudity, etc., including with body doubles, without express consent, no physical touching, etc., without consent, and then no rehearsal of or filming of artists, including artists' approved body double. Point 7, any nudity, partial nudity, or simulated sex without express written consent. You have that here on point 17 here. So we've got three of those 17 points are already covered by this one paragraph in her loan-out agreement. So she's got on permission for Todd Black and Giannetti. Yes, Todd Black was the producer. Great. There is something somewhere about the composer. But the big thing, right, for me, which made no sense to ever be in here, is that she managed to obtain control over Isabella Perez nudity rider because she was young Lily. And although her actual although her loan-out agreement says that no body doubles, etc., to simulate her likeness, the character young Lily was not hired to be Blake's body double. It was a different character. It was a younger version of her character, not of her. But I think she seized upon the opportunity, because one of the things you need to get the PGA is to, well, multiple things actually. Let's see if I can find it. Okay, so this is my post about what was required specifically, how some of the stuff she asked for in the 17-point list was relevant to her obtaining her PGA mark. The PGA has a list of requirements for meeting the criteria for obtaining the mark. As an actor, Lively would have needed to have carried out multiple duties beyond her role as an actor. And this is the producer-actor part, because do I still have it there? Let's have a look. That's producer, director, producer, actor. So this is the requirements for an actor to get a PGA mark, which applies to Blake Lively. In general, contributions to the actor's own character, marketing as an actor, and other creative input that is typical of an actor may not be counted towards the individual's producing duties if they also received an actor credit. So she had to do more than be an actor because she got an actor credit. Examples of creative contributions that are not typical of an actor include, but are not limited to, and shout out if you recognize any of these, selecting and approving principal cast and crew, for example, the director, cinematographer, editor. That will also include the composer, a producer. Consulting on the overall story arc beyond that of the actor's character. So that's writing script, changing script for other characters, not just her own. Consulting on and approving costumes. That includes blowing a budget on your friend's fashion line, which looked diabolical. Makeup and hair on characters not played by the actor. Viewing and commenting on dailies. Remember, she needed access to the dailies that do not involve the actor's character. She had all the dailies, including the ones of young Atlas and young Lily, which she was not even on set for. And consulting on the overall edit with the director, editor, studio, etc., i.e. hijacking the entire editing booth and making your own cut and telling Sony, if you do not let me have my own way, you cannot have my friend's song. Okay, so if in addition to performing the producing functions listed in category A below, which is required, an actor also has to personally perform at least 2 functions from category B, and that would be considered strong evidence that the actor has met the producer's mark standard. So let's look at this. Category A, the required bit. So you cannot get the PGA mark without this. Actor demonstrated that they personally made regular, continuous, and substantial decisions regarding production, budgetary, and legal concerns. Legal concerns. Oh, you're harassing people. I have to step in and put in place protections in a constructive and responsible manner. So, check. She hit that. In regards to production, budgetary, and legal, hit all 3 of them. Category B, so she needs 2 of these. There's 3, and she needs 2 out of the 3. Actor personally was involved with the project prior to all other producers? No. Created, identified, or secured the intellectual property on which the project was built? No. Secured the director, writer, or financing before the film was greenlit or a majority of the financing was obtained. Actor does not get credit for securing themselves as a critical element of the film. Nope. Or resurrected an otherwise stagnant project or significantly reimagined the script or production before the film was greenlit or the financing was obtained. So no, that's one. That's one element of category B, and no, she does not meet that criteria. Let's look at 2. Actor personally rendered substantial creative contributions to pre-production and production that are beyond those typical of an actor. Check. She hit that. She became a control freak and took over the pre-production and production. Well above what your average actor would be doing. And then 3, actor personally rendered substantial creative contributions to post-production that are beyond those typical of an actor. Well, she made her own cut. She promoted the film. She took ownership of promoting the film. She also stole a copy of kind of the unpolished film and took it to was it BookCon? That Colleen Hoover's book thing in Texas, and that was actually against her contract. She's not allowed to do that as per her loan out agreement. But that's a whole other story. However, there you go. That's how she got the PGA. And as far as I'm concerned, that was the entire purpose for the 17-point list. That's what that was always for. Yeah, I won't be. My mind won't be changed. Sorry, I forgot to have this screen on. I forgot to change screens. So here's the category as well. So if anyone wants to pause it to read it, I will also put a link to the post I did as well, the X post I did breaking that bit down too. So that's how she was able to get the PGA credit. So my whole take on this is I do think it affects the Title VII claims. This loan out agreement, that all the terms, all the information that's in there, which we've only just had, we didn't have before. I think it does materially affect her Title VII claims, as in she's not entitled to pursue them. She is entitled to pursue FIHA on the face of it. However, I think Wayfarer will make their extraterritoriality argument was solid, and there's nothing in this loan out agreement which screams that California should apply other than the choice of law provision. But Wayfarer provided good case law to even rebut that. So that's my take on it. I will. We still haven't had the unsealing of Steve Sarowitz's recording. I'm really waiting for that. But hopefully I'm hoping that will come out today. I don't know why it's taken so long. My hypothesis is that it's not going to come out as a recording. I think it will be a transcript, and that means someone will have to transcribe. And that might be why it's taken a bit longer. But in all honesty, I don't know what's going on. I don't know whether it's the new rules have affected anything. They shouldn't, because they only apply to documents whilst they're sealed, which only affects the parties. It doesn't affect documents being on the docket when they become unsealed as normal. Anyway, that's it for me. Thank you for watching, and I'll catch you at the next one.